All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, this great state of Florida, this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Bright versus State of Florida and Bright versus Secretary, Department of Corrections, numbers 2023-1735 and 2024-0876.
Good morning. My name is Elizabeth Spiaggi on behalf of appellant and petitioner,
Sorry,
Mr. Bright.
I apologize. Do you mind, can you raise that and speak up?
Absolutely. Is that better? Okay.
Thanks.
All right. All right. Mr. Bright went through a prior post-conviction proceeding after his 2009 trial. He was granted a new penalty phase, and we are here on the appeal of the denial of relief for that penalty phase in post-conviction. Additionally, we have Mr. Bright's state habeas, which addresses some issues from the penalty phase and some issues from his 2009 trial. I would like to focus first on the ineffective assistance claim relating to trial counsel's investigation of mitigation. Firstly, dealing with her failure to investigate Mr. Bright's military career. Trial counsel testified that she never looked into calling folks who had served in the Marines with Mr. Bright and never identified this as an area of inquiry for her investigator. The veterans who testified at the evidentiary hearing who had served with Mr. Bright painted a compelling picture of a diligent, hardworking, selfless Marine. They talked about the stress of that particular MOS, the military occupational specialty. They explained that in keeping these aircrafts running, the pilots' lives depended on them, and they were under a lot of pressure to sort of keep an available number of Harriers, that's the aircraft he worked on specifically, up and running. They talked about the physically grueling conditions in Cherry Point, North Carolina, and Yuma, Arizona, as well as on the carriers when they were at sea. At sea?
Can you point particularly to what effect this would have had?
So the jury did not hear anything about Mr. Bright's day-to-day doings in the military. They did not hear how stressful this particular occupational specialty was. There was really no humanizing of that military service in the presentation that was done. They had a fellow colleague, another attorney, read Mr. Bright's military records to the jury. So the jury really didn't get a sense of what he was doing in the day-to-day or hear from other people who had served with him. And I think it's very important because there's sort of a misconception that if you're not actively deployed in combat, military service isn't that stressful, but I think their testimony countered that and sort of corrected that idea that even in maintaining these maintaining the aircrafts, there were casualties in training, and the mechanics were sent to pick up the pieces of the plane
and
the remains.
Do you think that this would have resulted in?
Well, as it was, Mr. Bright's the sentencing court gave little weight to Mr. Bright's military career.
And we already reviewed that the original time, right, in 2020?
At that point, you didn't know what testimony was missing that would have impacted that.
In 2020, there was a little weight given to military service, correct?
Yes, right.
Right. And we said that that would not have outweighed the aggravating factors.
What I'm saying is that I think it deserves a lot more than little weight. I think that finding is an anomaly, especially when you hear about how dangerous his service was and how respected he was by his fellow Marines for his work and his willingness to help them.
Well, then it sounds to me like you're conceding that you want us to reweigh the evidence.
I am saying that there's not competent, substantial evidence to support the circuit court's finding in this instance. The circuit court found that trial counsel had made a reasonable strategic decision in presenting a witness who didn't know much about Mr. Bright's military career. I think just in sort of saying that to you, you can see how illogical that is.
Well, wasn't she concerned that there were things that happened, other things that happened at that time that would open the door for all of those questions to come out as well?
I think what we saw at the evidentiary hearing is that actually none of these witnesses knew much about Bright's transgressions. They were not part of the bigger picture of his military career. And so I think it actually would have refocused the presentation on what he actually did rather than allowing the state to make completely unfounded arguments about his career. There were for one example, I think the state argued that Mr. Bright was sleeping in the place where they worked on the planes, and at the evidentiary hearing, it came out that no, the write-up for him sleeping was for when he was in the dorm monitoring other people who lived on base in the dorm. So I think that's a big distinction between what the prosecutor's arguing and the picture that the prosecutor is trying to paint versus his actual service. And by relying on just the records, she wasn't able to sort of correct and counter that depiction. She herself, it seemed, didn't have a thorough understanding of those records because that particular write-up, I mean, it was right there. She relied solely on the colleague to testify and help her prepare. And I think what we pled was that she really needed somebody to help her gather these first-person witnesses who had served with him and had, actual testimony about what Mr. Bright had done with them. And if she had had an expert to help her organize those and to sort of better understand the records, it would have resulted in a different amount of weight that was given to this military service.
So do you consider this your strongest claim?
I think that the failure to investigate mitigation is the strongest claim. I think that the other part of that is also giving the jury some context of what happened in the guilt phase of this. And this is sort of typical in a penalty phase, that they will educate the jury on the basic facts of the crime, but it really didn't even happen here. So we also alleged that she should have called two of the state witnesses from the guilt phase, Mr. Brian Williams and Mr. Benjamin Lundy, who for one thing, they provided additional mitigation testimony about, again, what a diligent, hard worker Mr. Bright was and how clients asked for him specifically because they knew that he was the best at his job and that he would take great care in his work. But they also knew about the circumstances that were going on in Mr. Bright's house. They had testified in the original trial for the state that the victims were selling drugs out of Mr. Bright's home and keeping firearms there. But
this goes to the entire strategy that trial counsel testified to, correct? That she made a very intentional choice that they were not going to victim blame.
I don't think it's victim blaming. I think you have to remember that the jurors are looking at what I will admit are fairly gruesome pictures, and they need to understand how these events occurred. They need to be put into context of the crime.
And you are not, I mean, the strategy was there's, I think, a 16-year-old, is that right?
I believe one 17-year-old and a 19-year-old.
A 17-year-old and a 19-year-old were murdered. And she said, as a strategy, I'm not going to go to any of their potential misdeeds and blame them. I think a better strategy is to sort of plead for mercy and follow that path. So every single thing that you argued in your brief, 5 points, goes to that issue. So why do you think that that was an ineffective strategy?
Well, I believe there was a lot of talk from the court about victim blaming, but what trial counsel actually testified to was, I wanted this jury to know that I respected the prior jury's verdict. And to me, I can't make a lot of sense out of that. You're not telling the new jury that he's not guilty. You are simply providing background. I think her other, it's also about giving some insight into Mr. Bright's fear of the victims, which is something that the jury's absolutely allowed to consider. They're instructed to consider the circumstances of the crime. So I think she did a real disservice to Mr. Bright in not, I realize it's a careful balancing act to not villainize the victims, but at the same time, you have to provide some insight into what was going on in the house, that Mr. Bright was being threatened, that he had contacted law enforcement, that this was an escalating situation in his home to try and get these guys out of there, to stop running basically a drug house out of his home. And the folks who worked with him would have testified in the original trial as state witnesses, in the guilt phase, that his demeanor was changing. He had this mounting anxiety over these guys being in his home. I believe his sister testified to his childhood stutter reoccurring. So everyone sort of painted this picture of Mr. Bright really as at the mercy of these two guys who had sort of taken over his home. I think I'd like to address an issue from the state habeas, that being the improper prosecutorial argument that was made, that the jury should show Bright the same mercy he showed the victims. This was a very clearly preserved error in that counsel filed a motion in limine about, in order to forbid the prosecutor from making this type of argument. The motion in limine was granted, and an order was issued that he could not make these arguments. He made them. She objected. The judge overruled the objection and later acknowledged, oh, this was the issue from the motion in limine. So it was a preserved error, and it was not raised on appeal. I think this pretty squarely fits the ineffective assistance of appellate counsel. It's a preserved error that's meritorious. This court has reversed before on this argument. There's a good amount of case law forbidding this type of argument.
You have a case in which we have reversed on that alone?
I don't think you would be reversing on that alone, because on direct appeal she raised on direct appeal, appellate counsel raised other inappropriate arguments that were made by Mr. De La Rionda, and I think the other arguments were not preserved, so appellate counsel was arguing fundamental error. But when you combine that with the preserved error of the same mercy argument, you've certainly reversed on same mercy in addition to
Didn't we already find that those were not in error? We already affirmed?
No, because it wasn't raised on direct appeal. That's the claim, that appellate counsel was ineffective.
Right, but the other issues.
I'm talking about together, right? Doing a cumulative analysis. It was ineffective of appellate counsel not to have raised it with the other improper arguments that she did raise.
I'm sorry, which of the 17 issues you raised is the same mercy comment?
This was the improper prosecutorial argument that was raised in the state habeas.
No, of the 17 issues in your brief,
yes.
Which one is the same mercy argument?
I don't think we raised it in the brief. It's just in the state
So why are we
habeas.
talking about it?
Well, I'm also here on his state habeas.
Okay, so is it raised in that as well?
Yes, sir.
Okay, so I guess this goes to a larger point, which is help us sort wheat from chaff.
You know, I think what really needs to happen is that the prosecutors, maybe they need to be taken, they need to be given some guidance, because this is a very clearly impermissible argument. I'm not going to ignore.
Please don't change the subject.
Yeah, I'm not trying to change the subject. I feel I would be ineffective if I did not raise what are meritorious arguments. We have a duty to bring these claims in state court and make sure that they're ruled on if they have merit, which a large number of these do.
Can you point us to the one that you believe has most merit?
I think we're talking about it clearly. I think we're talking
The
about it
same
presently.
mercy argument is if you were going to pick the basis for a reversal here, you would rest your case on the same mercy argument?
I think it's dispositive for the penalty phase, in that it was clearly ineffective of appellate counsel not to raise the preserved error. Under prevailing norms, appellate counsel should raise claims that have already been determined by this court, in the sense that it's already been ruled on a lot, that you can't make this argument.
But where's the prejudice if we don't reverse on that alone? Then where would the prejudice factor fall?
Well, I think what we have here is we have trial counsel not presenting a very full picture of mitigation, because she didn't investigate, and then we have, in addition, the prosecution making impermissible arguments. So all in all, it's very damning for Mr. Bright. But I see I'm into my rebuttal time, so I will save the rest of my arguments for that.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Jason Rodriguez, Assistant Attorney General for the state of Florida. In my time before the court, I'll explain why this court should both affirm the denial of post-conviction relief and deny Bright's state habeas petition. I want to begin where we began with Mr. Bright, which was the military mitigation claim. And what's very clear, both based on the trial court's or post-conviction court's findings and counsel's testimony, is that counsel knew there was a lot of bad in those military records and made a strategic decision. I've got one buttoned-up witness that can present a good case to the jury. I know him. He's a former Marine JAG officer. He comes across very well. He speaks very clearly. And I want him to be the one to present all of this military mitigation to the jury, rather than trying to go and find other individuals that might end up wandering into territory that I don't want to touch. Some of the military witnesses down below did know some of Bright's issues, including about the court-martial, drinking, and things of that nature. So counsel made a reasonable strategic decision. We don't, in post-conviction, nitpick everything counsel does. Is it reasonable for an attorney to do that? And that's reasonable trial strategy. Regarding the context of the House, we again come into another very reasonable trial strategy. The state's position is not that no attorney ever could choose to take the route that post-conviction counsel is suggesting. It's that a reasonable attorney could choose not to take that strategy. And when we're talking about, and my recollection is it's a 16-year-old and a 20-year-old, that strategy is incredibly reasonable, and counsel affirmatively tried to exclude evidence of the younger victim's age and was unsuccessful in doing so. So counsel knew she had a problem on her hands and wanted to avoid anything at all that was going to look like she was blaming the young victims for their deaths. She said,
let me ask you about that. What did trial counsel specifically say, indicating in the evidence you're hearing that she was pursuing a strategy that involved avoiding blaming the victim?
So she said, and this is a quote, and I'd have to look at my notes that are over here, but she said, quote, "It would be a bad move to blame the victims," was one of the things that she said. She said that, I'm asking for mercy for Mr. Bright, who did terrible things, and I didn't think it would be a good idea to, go the opposite way with the victims and make it sound like they're responsible for their deaths. But her testimony on that issue is very clear in the record. I think it mostly comes out in the state's cross, where she's asked those specific questions, but it's very clear that that's exactly what she was doing. Moving to the same mercy issue very briefly. So one, this court has said in Merck that it doesn't reverse on same mercy comments alone. And by and large, the comments that were raised, the prosecutorial comments that were raised on direct appeal, this court found there was no error in them, with one exception. That one exception was that the mitigation, the prosecutor in closing said mitigation had to be proven to a reasonable certainty. That is the only comment that I'm aware of that this court found any error in at all, and it said it was entirely cleared up by the jury instructions. The prosecutor made a one-off offhand comment, and the jury instructions would have entirely cleared that up. So in that circumstance, when we're combining what's kind of a half same mercy comment with a totally cleared up by the jury instruction comment, we're really in the same position as Merck, where a same mercy standing alone would not be a reversible error. States argued in its brief that this court should recede from its same mercy case law based on, really the majority view of courts, including from the 11th Circuit, that have said this is really a totally proper comment. That when a defense counsel is able to get up and argue, you should show mercy on my client, the state is able to rebut that position by saying, show him the same mercy that he showed to the victims, and reminding the jury that mercy to the defendant is not the only thing that's on the table, but we look at the victims as well. And that is the majority view, including the view held by the 11th Circuit. Your Honors, if you have no more questions, and I know issue 12 Guardado was raised, but the court does not have any questions, then I'll stand on my brief. All right. Thank you, Your Honors.
Thank you.
Well, I'll try not to belabor any of my previous points. As for strategic decisions, in order to make an informed strategic decision, you have to investigate the case. So before, she can't decide without talking to people who served with Mr. Bright that it would be better for them not to testify. That's not an informed decision based on her investigation. The same is true, I would say, of the contextualizing the crime. Her co-counsel testified that they didn't look into this area. Her work product shows that she didn't research whether she could contextualize the crime. So even that decision, she was not an informed decision based on research. I would also, as far as the military mitigation, I would point this court to Porter, where the U.S. Supreme Court specifically held that even if there are transgressions in someone's military service, you have to present that full picture, because even with the transgressions, they're sort of overshadowed by the service to our country. And I would point out that in Porter, the transgressions were pretty big. I think he was AWOL for 6 months. Lesser so in Mr. Bright's case. In closing, I would just say that trial counsel's testimony about her strategies is contradicted and undercut by her co-counsel, her investigator, and the record from the penalty phase itself. I would ask this court to reverse the circuit court's denial of post-conviction relief, as well as grant a new appeal of his full trial based on the issues raised in the state habeas. Thank you.
Thank you very much. Okay, our next case is Bell versus State of Florida and Bell versus Secretary Department of Corrections, numbers 2024-1264 and 2024-1556. Whenever you're ready.
Thank you. Good morning, and may it please the court. My name is Adrienne Shepard, and I and my co-counsel Ali Shakur represent Jesse Bell. Mr. Bell is the appellant in this case. We are here on appeal from the Circuit Court's summary denial of Mr. Bell's initial motion for post-conviction relief filed pursuant to Florida Rule of Criminal Procedure 3.851. I intend to focus my argument on Mr. Bell's involuntary waiver of the right to counsel. As an initial point, I should state that it does appear that Mr. Bell's case is one of factual first impression before this court, and that a capital defendant is asserting that his waiver of his penalty phase counsel was rendered involuntary by abuse and mistreatment that he suffered whilst in prison while awaiting trial. With that being acknowledged, the fact that I do think this is a case of factual first impression, Mr. Bell's request for a remedy for this constitutional violation is based on legal principles that are not new.
Before we get there, can we talk about whether you think the Feretta colloquy or any of the other colloquies that your client had with the court were incomplete or mistaken as a matter of law? Can we put aside at the outset that the court did what it had to do in terms of colloquying your client?
Yes, Your Honor.
So once we've established that the court did the right thing, the question then becomes, why didn't your client, your client was demonstrably capable of filing things with the court and raising arguments because he did. So the question then becomes, why didn't he avail himself of those avenues and raise the issues you're raising now by saying, hold up, the Feretta colloquy failed to catch the fact that I'm being abused, and that was involuntary? Why should we look past that silence in the record?
Well, to respond to your question, Justice Curiel, I can make 2 points. So number one, Mr. Bell was being severely abused and mistreated by correctional officers at Florida State Prison. They were transporting him to the courtroom. They were in the courtroom. He was afraid of retaliation. He didn't know that if he stood up and...
Well, I hear you saying that, but I think he's still in the Florida State Prison, right?
No, sir. He's at Union Correctional Institution.
Okay, well, he's in the Florida correction system. So if he was afraid to blow the whistle then, but he's happy to blow the whistle now. I don't quite get that. Because he's basically subject to the same authority and subject to the same sort of situation he was in before. So it just doesn't quite add up that that he's blowing the whistle now, but but for some reason was unable or unwilling to before.
He is not in the same situation, Justice Kennedy. He escaped from the abuse that was happening from the Florida State Prison guards. It was well known to the inmate population at Florida State Prison that that particular population of correctional officers abused inmates who had a charge for attacking a correctional officer. Once Mr. Bell made it to what he saw as the immediate safety of Union Correctional Institution, he's no longer being abused. He's now safe. He can now talk about this. I would like to go back to my second point to your question, Justice Curiel. So Mr. Bell was afraid. The Florida State Prison correctional officers were in the room. Also, anytime he filed something as a pro se defendant, he has to hand that piece of paper to the correctional officers. He can't trust that they're not going to read it.
I guess the trouble with that argument is if he felt this pressure so acutely, why waive counsel? Why not just have your court-appointed lawyer blow the whistle and take other measures to safeguard you?
Yes, Your Honor. It speaks to how involuntary this choice was and the fact that it was not made in the absence of subverting factors. It was not clearly free and responsible. He sat at Florida State Prison for 6 months without the appointment of counsel, without a first appearance. He had no one to speak for him. After 6 months of being abused and denied food and the threat of abuse, I think it affected his mental state to the point...
I think if you're right, then we can never trust a Feretta colloquy. You're sort of proposing to us an unfalsifiable hypothesis that we can never trust that someone won't be in this sort of secret position. And that's why I started with whether you thought the Feretta colloquy was adequate. Because if you are making the argument you're making, then I think what you need to argue is that courts should always, or at least in circumstances like this, be concerned about voluntariness and, I don't know, colloquy the defendant in a closed court or something. Are you making that argument? Are you
No, Your
making?
Honor.
Okay, so then help me out. I don't understand, because it sounds to me like in a case where someone is alleged to have attempted the murder of a guard, what you're really saying is we should always just assume that this person is being exposed to risk, and therefore Feretta is inadequate, and we need to rethink how that person is colloquied about voluntariness.
I'll state first, to your point about trusting Feretta inquiries, we can, at a basic level, trust them when they're done correctly, and Judge Fina did the Feretta inquiry correctly. What we can't trust is Mr. Bell's inquiry, not because the trial court did anything wrong, but because of what we've discovered in post-conviction. I will state that because the lower court denied an evidentiary hearing, this court must accept the factual allegations in our briefing as true to this extent. And so there is corroboration of this abuse. As far as the court having to ask about abuse, not every single time. It's the case that Mr. Bell was incarcerated at Florida State Prison, where it's well known that guards would abuse inmates who had a charge for attacking a correctional officer.
I guess that takes me to my next point, which is, or question, which is help me understand, if any, the causal relationship between the abuse and the voluntariness of his plea.
Yes, Your Honor. To answer that, I would first state as a prerequisite matter that we really need an evidentiary hearing.
Well, is there allegations, though? I mean, you would agree that as a legal matter, in the context of an unintentional waiver, the causation element is legally significant.
It is.
What allegations do you think were raised to establish that causal connection, just as a factual allegation?
Yes, Your Honor. What we've argued in our briefing, and what Mr. Bell would testify to if he could at an evidentiary hearing, is that after being abused for so long, he couldn't see any other way out. It was about, how do I reach a place of immediate safety? How do I get away from Florida State Prison
today? So that would
today?
be causal to his state of mind, but isn't, from a legally significant standpoint on causation, it's that the abuse was, he was abused in order to procure a waiver, essentially. There needs to be that link.
Go ahead. My answer to that would be no, and I would point this court to the Figueroa Sanabria v. State opinion. Now, that is a little bit different.
No.
No.
Figueroa Sanabria is completely different. In Figueroa Sanabria, the court put a false choice before the defendant. The court was mistaken in conditioning a waiver on a selection about counsel, and you have forsworn any trouble with what the judge said in the Feretta colloquy. Figueroa Sanabria, respectfully, is of no help to you, unless you think I'm wrong about it.
I do respectfully disagree, and I was, to Justice Sasso's question, she was asking whether or not we had to prove, correct me if I'm wrong, that we had to allege that the abuse was for the purpose of causing the waiver. Is that correct?
Yes.
Okay. So in Figueroa Sanabria, the trial court, and perhaps I misread the opinion.
Or perhaps I miswrote it.
And I know you authored the opinion. There's no discussion in that opinion of Figueroa having to prove that the trial court misadvised him for the purpose of eliciting that waiver. The trial court definitely misadvised Figueroa about the nature of his right to counsel. And you're correct. In Mr. Bell's case, this is factually different. But what we're requesting is that this court take those foundational legal principles that Your Honor authored, that the waiver of counsel must be made in the absence of subverting factors so that the choice is clearly free and responsible. And I know that this court found in Figueroa Sanabria that Mr. Figueroa could not make a voluntary choice because he was forced into that constitutionally offensive decision based on trial court's misadvice. We are requesting that this court, or based on trial court's misadvice, we are requesting that this court take those foundational legal principles that are important and apply them to the facts of Mr. Bell's case. And so I would state that, in response to your question, there's nothing in the Figueroa opinion that implies that Mr. Bell must prove that the abuse was for the purpose of eliciting the waiver.
But you've conceded this is a factually new claim, novel. And I guess I'm struggling with, if we take your factual allegations as true, why would this not be closer to some competency issue rather than a waiver issue? It doesn't, to me, it doesn't fit into a coerced waiver when you're basically saying these conditions in his life created so much stress that he was in a mental state that he could not make an appropriate decision. That to me is completely different from what we typically see in the coerced waivers.
So my understanding of the competency, and we're not alleging anything related to his competency, is that you have to have a rational understanding of the proceedings and be able to rationally consult with your attorney. It's obvious, we acknowledge, Mr. Bell is smart. He had a rational understanding of the proceedings. He knew, if I waive counsel, I can get out of here. If I waive counsel, I can speed this process up. So the voluntariness comes from the fact that he didn't want to make that choice. He was forced into this constitutionally offensive choice from sitting at Florida State Prison for 6 months with no help, being abused, being denied food, and it got to the point where he said, I can't take this anymore. He understood what he was doing. He didn't want to do it. And I think under this court's dictates in Figueroa Sanabria, that can't be a voluntary choice, because it's clearly not responsible to try to reach a place of immediate safety by inviting a death sentence. But he was so tired, so desperate that he couldn't rationalize. And I think he constructively understood it, but he couldn't rationalize that I'm reaching a place of immediate safety. The guards aren't abusing me anymore, but now I face prolonged unsafety. Now I face a death sentence. It's simply not a voluntary choice. But we are not raising anything related to Mr. Bell's competency. And
well, help me understand again. I apologize if I've gotten the sequence of things out of order here, but when he had counsel, did he ever complain to counsel about the abuse?
So we don't know, and that's why we need an evidentiary hearing. We requested an evidentiary hearing.
But you made an allegation of that.
An allegation of what?
I mean, do you know? I'm just struggling to understand how there was not an opportunity to get this blow the whistle, as I indicated before.
As to trial,
because there's counsel. Well, let me just ask about the sequence of events. Do we know that the abuse was taking place based on what your claim is at a time when he still had counsel?
I do believe so, but I would say that the best way to answer that is to have an evidentiary hearing.
Well, we can always have an evidentiary hearing, but you've got to make allegations, and we've got to have some basis for that.
Right. Well, and the basis for the evidentiary hearing is Rule 3.851 subsection F, and that states that the trial court shall, not may, shall schedule an evidentiary hearing on claims asserted by the defendant as requiring a factual determination. We have several things that required a factual determination beyond what we were able to brief. Number one, what did trial counsel know about the abuse? Did trial counsel know it all? What could trial counsel do in a week? Why didn't the trial counsel tell the trial court? We don't know what we don't know. Number two, the other factual determination that was needed.
Well, but you're, again, it seems to me that part of your claim would be that he told counsel about it and the counsel didn't do anything. And that's why he was in this jammed up situation. He's going to know what he told counsel. You don't have to have a hearing about that. It seems like to me that would be part of your allegations to show that he was in this vice of abuse with no way to do anything about it other than to waive counsel and be off to death row. And I'm just.
So I respectfully disagree on the need for an evidentiary hearing, because even if Mr. Bell says, I told trial counsel every single time I spoke to him, we need trial counsel's side of the story. And I'm not saying that Mr. Bell's making anything up, but we need trial counsel to tell us what he knew.
Well, that might be it, but if you made the allegations and pointed us to that aspect of it, but without having made those, I'm struggling to see how this is other than something that's just kind of made up.
So you can see, though, that in the motion you're not alleging that your client told trial counsel anything.
We are not alleging that because we need trial counsel to tell us on the record.
Well, no, but I mean I understand what but it seems like your motion would have to sort of put that issue in play, and then you may need an evidentiary hearing to sort of flesh out, whether it's true and what consequences it had. So as far as just in terms of sort of just the kind of the doctrine here, I mean, so one way to get this in front of us in this context is through ineffective assistance of counsel, right? Which would involve you having had to allege that counsel knew. I mean, I'm suggesting this, that you would have had to allege that counsel knew something about this and failed to do enough about it to meet their professional obligations within the amount of time they had and everything. So that's kind of one sort of state, to the extent that the appointed counsel sort of is carrying out the state's obligation. That's that. So if the kind of state wrongdoing here is the correctional officers themselves, then what's the claim then? What's the, you know what I'm saying? How do you fit this into a post-conviction context?
I do want to respond to your Honor's question about making the allegation of something trial counsel knew. So we do make an allegation, an argument to that
in the motion?
In our briefing, in the initial briefing.
Doesn't, you have to, I mean,
yes,
the
in the motion, yes.
That counter in the motion.
Yes, if you look at the Rule 3.851 motion, in Claim 2, it discusses, particularly in subsection A, how trial counsel received a discovery exhibit from the state that listed an audio-taped interview that Mr. Bell had with a state attorney's office investigator in October of 2019.
That's the one where he says, "I was roughed up."
Yes.
And then they both laugh.
Yes.
Uh-huh.
And he may be laughing because he's scared. He's trying to put on a show. Also, we don't always know why people respond the way that they do to trauma. People's brains are different. But to your point, Justice Muniz, trial counsel did at least receive that discovery exhibit. What we don't know did trial counsel have enough time to listen to the interview? So there is some evidence indicating that trial counsel could have known, because he did receive that discovery exhibit. He was copied on it. We need trial counsel to tell us, did you listen to the interview?
I mean, so the allegations, though, sort of drive what then you would need a hearing for. But let's put the counsel's conduct to the side, and then could you just explain, because I mean, this is an unusual, obviously, as you started off acknowledging, this is an unusual sort of claim to be raising in post-conviction, and so just help us understand sort of, if we're just sort of trying to fit it into the available categories for post-conviction, how we would even get to this in this context.
I think and I know you're asking me to put aside trial counsel, the most obvious available avenue is trial counsel, but to try to provide another avenue of relief to answer that question, what we have is a circumstance, because this court has held on direct appeal, speaking about direct appeal for a moment, that the involuntary waiver of counsel that results in a complete deprivation of the right to counsel is fundamental error that does not require a contemporaneous objection at trial. Okay. Now, I recognize...
So that cuts against you, though, in the sense that that means that you could have raised it on appeal.
So, well, right. Mr. Bell could not have raised it because the abuse was not apparent on the face of the appellate record. So what we've requested in our briefing is that this court recognize in these very narrow, very specific circumstances...
Hold on. You're saying the ineffective assistance of counsel wasn't apparent on the face of the record, right?
No, Your Honor, the abuse.
But the involuntariness, they could have raised some sort of, I don't know what who the government actor who committed fundamental error would be, but I guess the point is, if they could have been raised as fundamental error, then we know that ineffective assistance of counsel cannot be raised,
of course,
on appeal, right? We know that if anything that could have been raised on appeal can't be brought in post-conviction, right? So by telling me that by then bringing me back to sort of direct appeal type stuff, you're defeating your argument for why we can take it up now.
I recognize the precedent that claims that could have or should have been raised on direct appeal are not cognizable in post-conviction.
Okay.
What we're asserting is that that the fundamental error, putting trial counsel aside, the fundamental error could not be raised on direct appeal because evidence of the abuse was not apparent on the face of the appellate record. There's nowhere, because Mr. Bell was so afraid to speak about what was happening, there's nowhere that direct appeal counsel could look at the record and say, oh, he waived because he's being abused. So we have this severe constitutional violation, this manifest injustice.
Is there any precedent for, outside of the ineffective assistance context, is there any precedent in post-conviction for essentially wanting sort of a do-over on voluntariness? I mean, it sounds like that's what you're essentially asking for.
What we're, right? I can't speak to any precedent, Your Honor.
Oh, so you don't know of precedent for that?
Not as I stand here now. And what we're requesting, not that this court overhaul. I see that I'm almost out of time. I've got about 30.
No, we'll give you more time.
Is that okay? Thank you.
No, because you're talking about, you started off by saying that you want us to sort of apply these first principles, right? And it seems like we've got the first principles on ineffective assistance. We've
Right.
got all the first principles about trying to do things during the direct appeal, which seem to cut against you. So I'm just trying to understand, because we have to fit it into a category that
Correct.
works for post-conviction.
I think
So what, other than ineffective assistance of counsel, which I think would depend on your allegations, which perhaps weren't there, but we'll look at it. But then if that box is not available, then what is available to you?
I don't believe there is another box available. And so what Mr. Bell's case represents is we do have a manifest injustice. We do have an extreme constitutional violation. But I think it just procedurally, we don't quite have the perfect box. We're trying to put a round peg in a square hole. And that's why we're requesting that this court recognize that very narrow exception, specifically just on the waiver of counsel, where a fundamental error has occurred, but it couldn't be raised on direct appeal. We're requesting that this court recognize it in post-conviction just for fundamental error, just for the counsel waiver. And so we're kind of asking for this court to extend the fundamental error doctrine to post-conviction.
Well, I mean, yeah, okay. I mean, I don't blame you for asking, but I mean...
That's what we're asking for, Your Honor. I see that I've gone over. Can I have 5 minutes?
You
Okay.
can have 3 minutes. And if you want to wrap up, you can take 30 seconds to wrap up, too.
I'll wait until rebuttal.
Okay,
Thank
thanks.
Mr. Chief Justice, may it please the court again. Jason Rodriguez on behalf of the state of Florida. Your Honor, as Mr. Bell did, I will also focus on the counsel issue, and I think really where we ended is a good place to start. And that's that when we're dealing with this issue, it is an issue that could in fact have been preserved and raised on direct appeal.
In fact, on direct, am I right that Bell raises as a mitigator the court engages with, and then we on direct appeal consider the following? Bell says, in mitigation, hey, I've never abused any other guards at the Correctional Institute, right?
Yes.
Okay. I make of that fact that he was willing to discuss the subject of abuse, and indeed he said, hey, in my defense, this is the only guard I've tried to murder. Wouldn't that have been a pretty good time to raise the fact that he was being abused?
I would think that basically any time with counsel, we know he had conversations with counsel beforehand. He's appointed counsel, I think it's on December 5th. There's some conversations about him wanting to waive. There's consistent conversations after that up until the 13th where the court asks him, have you talked with counsel? And he says, yes, and I don't want counsel. So I think there's a number of opportunities where he can speak with counsel who is supposed to be the one who's his advocate, and then who can take whatever remedial measures need to be taken, whether that's, setting an ex parte hearing with the court if it's bad enough, doing it with just whatever needs to be done. Counsel's the vehicle to do that. The case that Mr. Bell cited was Farr versus State, where something similar was alleged to have occurred, and that's exactly what the inmate did. And Bell certainly, as this court, I think, analyzed in his competency or the competent substantial evidence on his plea and everything on direct appeal, he's not shy about telling the court what's going on. So I think very easily this is something that could have been preserved and raised on direct appeal, if only through the avenue of counsel. As it pertains to kind of where we ended, we're in an area where this court said this is an issue that's procedurally barred, or this type of an issue is procedurally barred, rather. It could have been raised and developed on direct appeal. In fact, to get to kind of the allegations they raised in their 3851 motion, they did not allege counsel knew. They alleged counsel should have investigated based on the J.T. Williams interview with Mr. Bell about the abuse, and should then have found the inmates Boatman and Womack. There was no allegation that counsel in fact knew. It was counsel failed to investigate the issue, in essence.
And so in order for us to be able to evaluate that, the amount of time is a relevant consideration, right? And so what's the amount of time it's a pretty short amount of time. I can't remember exactly.
So I counted about 12 working hours from when the state files and gives the interview that should have prompted all this, according to Mr. Bell, until the waiver colloquy, roughly. It's about 2 days, I think, straight, but it's about 12 working hours. And under no circumstances is counsel going to be ineffective for failing to investigate the massive quantity of information that the state gave him, find that singular interview, and then go and interview and find 2 other individuals. So If there was an allegation that Mr. Bell told counsel he was being abused or that counsel knew some other way, we'd be having a different conversation. But they have access, and part of the whole purpose of 3851 is they've got a year to investigate their claims, to ask counsel these questions, to ask Mr. Bell these questions, and then make good faith allegations. If there's a conflict, then they get to make the one that's most beneficial to them, and we have an evidentiary hearing. But that wasn't what was raised here. So this is a situation where we've got a procedurally barred issue that cannot be raised in post-conviction. And I would push back as well on the concept of manifest injustice in this sense. When we're dealing with just the waiver of counsel, that I don't think gets us to a manifest injustice in and of itself, because he still would have had complete control of the mitigation that he presented. It doesn't get us this idea where there's no possibility that he would have received a death sentence. And when we're talking about manifest injustice, an incredibly high standard that this court has very rarely found. The only illustration that jumps to my head was a biased judge overrode a life sentence and sentenced a capital defendant to death. So it's a rare circumstance. I don't think that part's been fleshed out in the briefing, but I don't think this fits into that paradigm in this context. The court has no further questions. The state will rest in its brief and request the court affirm.
Thank you.
Your Honors, I'd like to address 2 brief points and then conclude. So number 1, about ineffective assistance of counsel and what we need to allege. It is cognizable if we allege that counsel had leads on an investigation and failed to pursue them further. That can be ineffective assistance of counsel. You know you need to look into something. You don't look into it enough. You have to make a reasonable investigation. We don't have to specifically say that he absolutely knew about the abuse. We have to say that he should have known about the abuse. He failed to investigate it further. That's deficient. That is what happened here. He should have known. He had a discovery exhibit with that interview. He should have known. Now we need him to tell us why he didn't know or why he didn't investigate further.
Is that discovery exhibit the sole piece of evidence of what you now claim is the sustained systemic abuse of your client?
No, Your Honor. As far as the evidence of the abuse, we have the allegations in the briefing and the 2 affidavits from the inmates who were at FSP with Mr. Bell and knew the abuse was occurring. So I also want to speak to...
I mean in the record before counsel at that time.
Yes, I'm sorry.
That's it. That's so.
From what we know.
Okay, so
Yes.
counsel would have had to find from that one statement that there was this crushing abuse going on that was rendering his decisions involuntary.
Not necessarily. That should have prompted counsel to speak to Mr. Bell. And I want to speak to the fact that as for the 12 working hours, we do not know that. That's nowhere apparent on the face of the appellate record. Trial counsel needs to tell us how many hours he had to work. That is asserting a fact into evidence that simply is not there. Trial counsel is the best person.
What does the record, just sort of the face of the record, show about the timing involved?
Sure. So the first appearance was on December 5th, 2019. The waiver was about a week later on December 13th, 2019. So yes, it's a short amount of time, but I submit that in a week, counsel could speak to his client. I see that I'm about 1 minute in, or 1 minute left, so I won't get to my second point. I'll simply conclude that we are requesting that this court remedy the extreme constitutional violation that was caused by Mr. Bell's involuntary waiver of the right to counsel. We've offered 2 avenues for relief that this court may take in the briefing. The first, of course, is to remand for an evidentiary hearing pursuant to Florida Rule of Criminal Procedure 3.851F, so that we can have a full and fair evidentiary hearing and get all the evidence on the record to answer your Honor's questions. In the alternative, under Figueroa Sanabria v. State, we are requesting that this court vacate Mr. Bell's death sentence and remand to the lower court for a new penalty phase where he can safely apprise himself of the right to counsel. And if your Honors have any further questions of me? Okay, thank you. I appreciate it.
You both sides did a great job with the interesting case.
Thank you.
All rise.
Congrats.